I'm just going to go over our normal housekeeping and instructions. Please be advised this is not legal advice. We are here only to give general legal information. The chat function is intended for questions or requests, for clarification and commentary. And again, the chat feature is not to be considered legal advice under any circumstances. We would like to remind everyone that you may review our recent Q&As for the primers on the upcoming legislative changes that everyone has been discussing. You may email us at info@condolaw.net with any suggested topics for these primers. And also to remind you that CA Day is coming up in October. Please email us again at info@condolaw.net if you have suggestions for presentation topics. We do want to remind everyone that some changes for WUCIOA will be taking effect on July 27th, and that several provisions will become binding on all communities effective January 1, 26. These relate to meetings, voting, and collection notices. Also, be advised our Q&A is canceled for this July 2nd. I hope you all enjoy the 4th of July holiday. Let's see. I think that's all. Chelsea will be adding things to the chat as we go along. I will be getting started with the first question. Question is, can you discuss if an association were to draft an anti-harassment or code of conduct statement, what would that be classified as? By that, I mean, would it be an amendment to the declarations, or can it be added to the rules and regulations? One seems more formal and the other less expensive. To answer your question, an anti-harassment code of conduct pertaining to owners would be treated like a collection policy, rules and regulations. For a non-WUCIOA community, this does not require a vote or any type of specific recording. If you are a WUCIOA community, it would be required that you first distribute the draft to the ownership, give them an opportunity to comment before it's adopted. In the case of non-WUCIOA and WUCIOA communities, reasonable notice is always required before such a change could be effective. So a note here would be that if you are talking about, it's not clear from the question, but if in the specific situation where you're asking about an anti-harassment or code of conduct pertaining to board conduct, in that case, we would recommend that you have your association attorney draft it and include it in the bylaws. And when we draft bylaws, we typically include an anti-harassment and code of conduct statement in there that is recorded with the bylaws. Ken, did you have anything to add there?
No, just I guess I would comment that these are very difficult kinds of provisions to enforce because they are often vague and the specific conduct is not often addressed. So it's kind of like, you know it when you see it, but you can't describe every potential circumstance. So it's not a cure-all to solving problems on how owners conduct themselves. But next question. I have a question about resale disclosures that was brought up by one of my managers. Do past major repairs to a condo unit need to be disclosed on a resale certificate, or only planned current or future major repairs? So the short answer is that past repairs do not have to be identified, whether it's to a unit or the building. There may be an obligation for an individual owner to disclose something which has happened in their unit under the real estate disclosure laws, but those don't apply to the association. So the resale certificate addresses the current and future conditions. The reserve study should be addressing future major repairs that will be required. And to some extent, the reserve study and your past board meeting minutes are likely to also discuss major repairs which have taken place. And So that is a way for an owner who is, or a buyer who's particularly concerned about the history of a unit to better understand the history of the unit. So I'm not exactly sure what the question is supposed to be about, whether it's about a modification done by an owner or whether it's a past repair for something like a fire or flood. But the resale certificate does not have a requirement for that. It has a requirement for future repairs. Anything you want to add, Tima?
Yeah, I would only just, again, distinguish between the difference between disclosing future expected repairs or a special assessment on the building itself or the common elements versus an owner's particular unit. If it pertains to an owner's particular unit, that wouldn't typically go in the resale certificate unless there was some type of compliance or code violation. Otherwise, any type of owner disclosure would go into the seller's disclosure, and that would cover that type of detail. So the next question, where can we find information or case law where courts have found that smoking is not considered a nuisance in common interest communities? So the specific question is pertaining to Washington state law. Washington state law held in a case, Bofoli v. Orton, has held that smoking on private property is not a nuisance under Washington state law. And while a homeowner could pursue a claim for smoke generated by a business in the specific circumstance here, it could not pursue a similar claim against an individual lawfully smoking cigarettes on their private property. This is an unpublished decision. However, I did want to distinguish between Washington state law, common law, and the specific CCRs for your association. Your specific association can have a more strict rule saying that smoking is a nuisance, and when we draft CCRs, we always put that in there. So the third thing to remember is that the law can change. So for now, Washington state law still holds that smoking is not considered a nuisance on private property, but that state law could change at any time. Ken, did you want to add anything to that?
Yeah, we have a lot of clients that cite to city and local regulations that prohibit smoking within 25 feet of an open window or door for a commercial property. But the court held that those were commercial properties, not private properties, and that the 25-foot rule did not apply to condos because they were not covered by that statute. And, I'll offer, there were a lot of people who were very disappointed in our legal system not being willing to accept that secondhand smoke was a risk. But the courts looked at, 150 years worth of historical cases and couldn't find anything to support the idea that under common law that smoking was a nuisance. And the particular case involved was a townhome community with side-by-side townhomes. And there were no CC&Rs or other covenants that could be considered in addition to the common law. Next question. In today's Q&A, you posted in the chat the sections of RCW 6490 that were to begin in 2026. My question is, I didn't see 6490 455 on voting. I thought that was one beginning in 2026 as well. Can you clarify, or if I just missed it, or is it not included? The answer is 6490 455 about voting does not apply to all communities effective 2026. That's in part because all of the statutes were amended to fix the voting in 2024. Now, there are changes in 2025 to the voting requirements, especially about how you send out written ballots for elections and who gets to count votes during an election. But for some reason, the legislature did not make those effective for all communities in 2026. So you would still be using the voting section of your original statute. There is a specific list in RCW 6490-365 of those statutes which go into effect for all communities on the 1st of January coming up. And hopefully Chelsea is going to take this list and give it to you. 5 of them already apply because they relate to things like budgets and reserve studies. And it looks like there are 6 new ones. The most significant one being 445 about meetings and the requirement for open meetings and comment periods and executive sessions, but also the section about emergency powers of the board and emergency meetings takes effect on January 1st. And you can look at the list and see if there's anything else you care about. And it wouldn't surprise me if we have in the next executive or next legislative section another, quote, corrective bill to start including more of these provisions. I'm anticipating that as we come closer to having a single statute for all communities, we're going to see legislative changes every single year. So, anything you want to add, Tina?
No, nope. I think that covers what we know as of now. Question number 5, the WSCAI Journal has stated that effective January 1, 2028, mediation is required before a court will schedule a hearing on any matter. The answer, so essentially, and then it goes on to say, some industry experts are telling me that mediation for any dispute between an owner and their association will be mandatory before you can go to court. Is that true? So the short answer is no, that's not correct. That the Senate Bill 5686 does not require mediation, only that the owner be offered the opportunity to mediate. It doesn't require mediation. And this does not affect other types of disputes. This is specific to owner-related collections matters. And another thing to note is that your governing documents may have a provision in there that requires alternative dispute resolution for specific matters. So regardless of what the law says, your governing documents may have their own specifics regarding the process for escalating a matter. And so you will need to make sure and read over that and make sure that your governing documents do or do not have an ADR provision. And if it does have an ADR provision, it may pertain to certain aspects and not others of the, of a dispute. Ken, did you want to add anything more to that?
Yeah, I just think the journal got it wrong. There is a mediation requirement for foreclosure actions, which is coming into effect. I don't believe it takes effect until 2028 for anything that's not a WUCIOA community. And even the WUCIOA communities, I think there's a delay on it. And it is specific to mediation before foreclosure. So I think that, mediation may still be a good way to try and resolve disputes, but it's not mandatory before you can get a hearing with a judge. Next question. Our association recently amended our governing documents, which now includes quite a bit of the language that was contained in board-adopted resolutions. We are now governed by 6490 WUCIOA, if that matters. The board would like to repeal all of our current policies and start over, if needed. Is sending notice to the owners of the intent to do so required? So the short answer is that to actually repeal a policy or rule under WUCIOA does require giving notice to the owners and an opportunity for them to comment before you do it. Telling them you're going to review the documents and may consider repealing them would not require any kind of notice. So the statute is 649505, and it is very specific in its text where it says that if you are going to adopt, amend, or repeal a rule, that you must provide the text to the owners, tell the owners a date on which the board is going to act on the proposal, and give them an opportunity to comment before the board has made its decision. So because the statute specifically uses the word repeal, if you're going to repeal a policy, you need to give notice to your owners. Anything you want to add, Tima?
I would just say as a practical matter, it's not a bad idea when you send out this notice to the owners to include a cover letter explaining what you're doing and why. Because you may be able to nip in the bud some of the questions that you might be getting for this proposal. So it's just never a bad idea to disclose that in a cover letter to your ownership when you are asking for that commentary. Question 7. When drafting a maintenance responsibility chart, which is better and why? 1, to amend the chart into the declarations, or 2, to keep it as a separate policy document, for example, at the level of your house rules. I would say you definitely would like to have, I highly recommend that you have an association attorney draft this type of document. Governing documents can have maintenance provisions embedded in as many as 5 or 6 different, sections of the declaration, and the language that you use and the thoroughness with which you address a maintenance policy and responsibility is extremely important to avoid confusion on the part of the ownership. We typically include these types of maintenance responsibility agreements in any restatement that we draft, because this is a recorded document. It will carry more authority than a standalone document. So that's our recommendation. You can, let's see, what else was I going to say? Ken, did you want to add anything to that?
Well, I would just say that if you like the way that your current documents allocate maintenance responsibilities, then a maintenance matrix or a chart that just helps clarify it works fine. But if you're trying to change anything, you'll need to have an amendment to the declaration. So if you're trying to clarify who pays for windows or doors, or the pipes and wires that are serving only one unit, and your document doesn't have clarity to it, then you probably will need a declaration amendment in order to make that change. And there are a lot of condominiums which are constructed as townhouses, where people believe that the individual owners should be responsible for their townhouse in the same way that you would be for a single family home. But because the boundaries of the units are defined under the original statutes as the interior, perimeter walls of the dwelling unit, that technically makes almost all of the structure and many of the wires and pipes common elements. And so if you have, especially an older townhouse community, adopting an amendment to clarify how you want all of the parts of the building to be maintained, whether it's an association or owner responsibility, can be very helpful. It might also allow you to clarify your reserve study, because the reserves only have to be collected for those components which are maintained by the association. And there are some condominiums and townhome communities where the entire structure is within the unit boundaries, and the association maintains little or nothing, or they may maintain only the roof and the exterior paint. So if you're trying to get clarity, it's probably best in the declaration. Anything else, team, on that?
Nope. I think that covers it.
Next question. I'm confused. The past few Q&As have stated that SB 5686 comes into effect for everyone in July of this year for written notices of delinquent payments, foreclosure, etc., etc. This is the statute or the bill this year, which relates to delinquency notices. Then it says, however, I read the last bill signed by the governor does not appear to be taking effect in July. I think we just answered this question with regard to when the notice of delinquency is required under the statutes. So I guess the short answer again would be that for non-WUCIOA communities, we believe the statute takes effect on the 1st of January 2026. But there's also no harm in sending out those notices starting now. And that if it's a WUCIOA community, it is effective on July 27th, 2025. And you can correct me, Tima, this is the one which would require that within 30 days of a payment being missed, that a special notice goes out advising owners that a failure to pay could result in foreclosure and identifying for them resources that they can go to for help with delinquencies. Is that correct?
That's correct.
Okay.
So that goes into effect July 27th of 25 for existing WUCIOA communities. For all other communities, it goes into effect January 1st of 26. Question 11. The current and upcoming statutes cover liens and foreclosure steps for late and unpaid assessments. However, it says nothing about the process for collecting fines for CCR and governing document violations. We have homeowners that refuse to comply with the CCRs and are being issued fines. However, they refuse to pay the fines, which in one case are exceeding $1,000. Do the same collection, lien, foreclosure, and notice statutes for assessments apply to fines? Yes and no. So the first answer, to clarify, fines are considered a valid enforceable assessment, meaning that they are not treated differently from an assessment or any other type of owner's responsibility, financial responsibility. That being said, when you ask the question, do the same lien, foreclosure, and notice statutes for assessments apply to fines? The answer is no. If I am looking at a ledger that is only fines, you must keep in mind that the foreclosure requirement is a $2,000 minimum threshold, not including fines, late fees, interest, attorney's fees, or expenses, or security deposit. So in order to, foreclosure is not an option for a fine-only assessment balance. That being said, you can send a demand letter, we can record a lien, and we could pursue this with a personal lawsuit. But we cannot foreclose on a fine-only owner balance. Let's see. Yes, and then other options would be small claims court or personal lawsuit. I didn't mention small claims court. That is also an option. To obtain a personal judgment to be paid by the owner, and then once you have a judgment, then we can collect upon that judgment through garnishment, other options. So I think that answers the question. Ken, do you think I missed anything there?
Well, it's also possible for an association to file a lawsuit to force a owner to comply with the CC&Rs. In other words, collections is a process of trying to get money. If your goal is to have compliance with the CC&Rs, the courts can provide injunctive relief, meaning a court can order an owner to comply with the CC&Rs. And so associations can certainly go to court to get compliance if they find that fines are not effective. Next question. In general, does the law support removing a board member position as an officer if the condo documents do not address this? What are the general reasons for such an action to remove, i.e. a vice president from being the vice president, to being only a board member at large? Okay. So the answer is that the condo HOA and WUCIOA statutes are silent on this particular matter, but the Nonprofit Corporation Act, which is 24.03A in section 595, does specifically address removing and appointing of officers. And it basically says that except as provided in the articles of incorporation or bylaws, an officer may be removed at any time with or without cause by the board. And so because almost all of the associations are required to be nonprofit corporations, this statute supplements the homeowner association or WUCIOA statute and gives you the authority to remove a board member at any time. You don't have to have a reason. You don't have to have cause. If you want to change a person from being the vice president to being a member at large, you just need a motion at a board meeting and a majority of the votes in favor to do so. Anything you want to add, Tina?
I mean, I guess I would ask, what are you trying to accomplish by changing the role from a vice presidency to one of a board at large? What's the reasoning for that? I don't know that. But, essentially an officer role is not really that distinguishable from a regular board position role when it comes to the authority, because the board acts as a whole. So just want to make sure that that's clear. The next question is, please explain the advantages and disadvantages of the association bidding on one of their condos at a sheriff's sale. If the association wins the condo at a sheriff's sale, what can they do with it? Could they pay off their remaining mortgage and then sell it? So I think first things first, a sheriff's sale is not confirmed without an opening bid. So the opening bid is the credit bid for the plaintiff at the association. The amount can be less and you can be less, but you're not going to set the bid higher because any extra amount is just going to go to the court or to the owner. So once a sheriff's sale takes place and once the sheriff's sale has been effective, there's always a 1-year redemption period post-sale. Keep that in mind. And during that time, the owner is unlikely to pay dues. So that is something that, is just unlikely. The owner is going to say, oh yeah, my condo's been sold at a sheriff's sale, and now I'm going to pay my dues. And also to keep in mind that the sheriff's sale is subject to the mortgage balance. So if a third party offers more, the HOA is going to get paid regardless, and the property goes to the buyer. So those are the sort of the general scenario of what a sheriff's sale looks like. You want to keep in mind that the pros here are that Seattle real estate market is very strong and there's likely to be equity. If the association buys the property, they could probably sell it subject to the mortgage. And if it's not owner occupied, it could be immediately occupied or rented out until the lender forecloses. Without more specifics, I can't really answer the question beyond the general question that's being asked. And I would say that, again, these situations can be very fact specific, but based on the facts I've been given, that's my best answer. Just thinking, yep, I think that's all I've got for that one. Ken, did you want to add anything?
No, I'm going to defer to you on that. So next question is, what are owners allowed to say when discussing with other owners their concerns about directors? So let's see, does a director have a limited or unlimited right to prevent other directors from viewing correspondence of the association? Do officers have rights to limit access to directors that do not hold an officer position? Okay, so the short answer is that owners can say whatever they want anytime. There is a First Amendment that basically lets them do that. So there's really not a way to control what owners are saying, other than by how you conduct yourselves. With regards to limiting the rights of other directors to view correspondence, I'm not exactly sure what you're asking, but generally, unless a board member is an opposing party in a legal dispute, every board member has the right to review every piece of information that's coming to or from the directors. The president can't withhold information from the other directors. And so if the president receives a legal opinion, the legal opinion is for the board of directors. It is not for the president. And it should be shared with the owners. The only exceptions come where you have a board member who is, I would say, actively engaged in a dispute with the board, in which case you may need to have a committee of the board set up to deal with your attorney and to provide an attorney-client privilege between the association's attorney and that committee, so that the information is not discoverable by the board member in dispute. Because there's nothing that prevents a board member from suing, even while they're on the board, the association. So if you've got a situation like this where you think that a owner who is on the board should not be given a document which has been provided to all the other board members, I think you need to have an attorney advise you on whether or not there are any legal basis to do that and what risks you have. The statutes for records and the rights of owners to review records were all substantially rewritten in 2024. And so the board member has the same rights as every other owner. And then to the extent that the document is privileged for the purposes of the statute, all board members have the same rights to review them unless you can demonstrate there's some legal basis for avoiding that. Anything you want to add, Tima?
I don't think so.
Well, the other one thing I would say is that directors do have a duty to keep confidential any of that information. So the fact that a board member is allowed to view an attorney-client communication does not mean that that board member has the right to distribute it to any other owners. The board does have the ability to waive privilege and share an attorney-client communication with all owners, but it has to be a board decision, not an individual board member making that decision.
The next question. Our HOA of single-family homes was established in March of 2013 under RCW 6438. A home sale is pending. No one has asked the HOA for the governing documents. The title company only wanted to know if the annual assessment had been paid. They wanted to know some insurance information and if there was a special assessment planned. The buyer's name was not provided. Whose responsibility is it to request an HOA's governing documents for a buyer so they can review them prior to the sale? The short answer to the question is no one is required to request an HOA's governing documents because there is no, and in addition, there is no resale certificate requirement for HOAs. Under the old act and the new act, under 6424, 425 do require a resale certificate, but an HOA does not. And so therefore, that being said, just because it's not required doesn't mean that we don't strongly recommend that you provide them to perhaps the title escrow or the owner's real estate agent in advance, and say, please share these with the buyer or a potential buyer. And obviously, if they're requested, you must provide them. So that's like I said, just because it's not required that anyone request them doesn't mean that you shouldn't provide them. It's obviously in everyone's best interest for the buyers to see the governing documents before they purchase the property. Ken, did you have anything else to add to that?
Yeah, so when WUCIOA takes effect, the WUCIOA specifically states that it is the seller's obligation to provide the documents, but it is the association's obligation to prepare the documents, which is kind of a weird twist. So under the current condo statute, the seller is who has to provide the resale certificate, but the seller has to get the resale certificate from the association. And that's how it will work under 6490, 640 going forward. The documents are recorded with the county. So, I mean, the CC&Rs. So there is no ability for an owner to claim they didn't know they existed. A title search would find them. And so, I would say for the most part, homeowner associations don't need to worry about whether or not a buyer has received the governing documents or not. All of the provisions of the CC&Rs are enforceable against that new buyer once you learn who they are. And that is the end of our questions that were submitted in advance. If people had other questions, they could put them in the chat. Chelsea, did you get any already?
Yes. So the first one I've got is, are municipal pet regulations unenforceable by city authorities on non-condominium properties and roads?
Well, I would think that municipal codes would be enforceable by the municipality in any part of the city. So I'm a little confused by the question. If there's a requirement to have pets on a leash in the city, they would be enforceable by the city on the roads. They would not be enforceable by a condo association on public roads.
There was clarification saying, sorry, on their private property, and sorry, didn't mean to non.
Okay, well, I'm a little confused what the question is. If the question is, can a homeowners association enforce the city's pet codes? My answer might be maybe. Many of the CC&Rs for communities are written so that a violation of the city code is a violation of the governing documents. And in that case, you would have the ability to enforce the city code because it's specifically granted in your CC&Rs. Many of the community CC&Rs have a broad and wide-reaching nuisance or offensive conduct provision where anything which is a nuisance or offensive conduct is prohibited and the association could enforce that. So if you could demonstrate that the failure to comply with the city's code was also an offensive or nuisance conduct, you'd be able to enforce under that provision. And the city code might be a reasonable basis for determining that the conduct was a nuisance. So if there was a requirement to have a dog on a leash, and you could demonstrate that the failure to have the dog on a leash was a nuisance, then it might become something which the association could enforce. But I'm not sure that the fact the dog is off leash, meaning violating the city code, is going to be enough to demonstrate that it was also an offensive or nuisance type of conduct. Any thoughts, Tina?
No, I agree with what you've said. I think that makes sense.
All right. On the collection issue, if an HOA cannot get to $2,000 dues within 5 years, why would we threaten a foreclosure? That can't happen.
So the question is, if there's no authority for foreclosure within the statutory period, why would we threaten foreclosure? I guess I don't know. What are you, I'm not sure what the question is. Is this regarding the notice to the owner that we're talking about for Senate Bill 56, that 5686 that's going into effect? Because the notice requirement isn't specifically about foreclosure. It's specifically about the fact that the account is going into collections and to give notice that mediation is an option. So I'm not sure I understand the question entirely, but
Yeah, I would say the
threatening,
association should not be threatening to foreclose
yeah,
if you know you cannot, based on the $2,000 threshold.
yeah, and we don't recommend that, I guess. So when we get a new file for foreclosure and a new file for collections, I apologize. We look at what the annual assessments are. In the case often of an HOA, where the assessments are annual and they're not very high, we are very direct with our clients up front to say foreclosure is not an option in this case, because the assessment only balances what we're looking at. It's going to take 20 years or 10 years or whatever it is to get to that amount. Let's look at our other options. So that would be something that should be identified early on in the process, the collections process.
All right. We also have, when an association has a requirement for a board member to be on title, does that restrict common property owners?
Can you
So-
repeat the question? Sorry.
When an association has a requirement for a board member to be on title, does that restrict common property owners?
So I'm going to assume that when you say common property owners, you're either talking about a corporation or an LLC or a trust, or some other form of entity, which is the owner. And you may or may not be talking about a married couple where only one of the persons is on the title. With regards to corporations, LLCs, etc., the statutes are very specific in stating that when the owner is one of those entities, that a shareholder of a corporation, a partner in a partnership, a member in an LLC, trustee or beneficiary in a trust, all of those people qualify as being able to serve on the board of directors. That's written into WUCIOA and into the Condominium Act for sure. So I'll say it's unusual to see a provision in a set of bylaws that specifies that the person has to be on the title. I've certainly had a number of clients who have made an assumption that they have to be on title, and I'm not sure that's a fair assumption. It is necessary to, I would say, have some demonstrated ownership link in order to comply with what I was discussing earlier about the business entities. In the case of a husband and wife where only one of them is on title, if they're living in the property, under Washington law, the property would be considered a common asset of the marital community. And we would normally say that the undocumented spouse, meaning you have documents to show they're married, you just don't have them on title, that they would still actually have an ownership interest in the property and would probably be able to serve on the board. And unless you had some convincing reason to try and keep them off, we wouldn't challenge it. If the spouse is not on title and the couple does not live in the property, then it's possible that the property is part of a separate estate for that one spouse. And in that case, the married partner could be excluded from serving on the board. But you start getting into very fact-specific details, and that doesn't work well in trying to answer a general question like this. Anything you want to add, Tima?
No, I don't have anything to add. It's a very specific question.
We got clarification on one of the prior questions. Says, my clarified question is, can the board refer to city authorities to enforce our pet regulations when they are aligned with the city? And can the local authorities enforce on the condominium's private property?
Well, I would say that if the city has a rule about, for example, the maximum number of dogs allowed in a home, that they can certainly enforce that on any property within the city, and that would include those within a homeowner association. So you can certainly call the city or the animal control for the county to try and enforce any regulations, and they can choose whether or not they want to. But yes, they can enforce their regulations within the municipality. We often will actually recommend that if you believe an animal is a vicious animal or is a threat to neighbors, that you also use the county or city animal control to get enforcement help, because they can act much faster. Plus, they have often I'll say, greater credibility in evaluating whether or not there's a risk and whether an animal is a vicious animal and needs control.
All right. The notice of delinquency sent when past due says, this is the first step in the loss of your home. Isn't that a way of threatening future foreclosure?
Now I understand the question. So this is referring to the statutory notice of delinquency, which we didn't draft that, but I understand what you're saying here. So what it actually states is, this is a notice of delinquency for past due assessments from the apartment unit or homeowner association to which your home belongs. This notice is one step in a process that could result in your losing your home. So I didn't draft the language. Is it perfect? No. In many circumstances, foreclosure is the result of this type of notice. In some cases, it's not an option. So I think, again, it's not really a one size fits all, but it is a notice that shares the information in a way that could be interpreted as a threat, I suppose. But unfortunately, I didn't draft the language. And it does say could result in your losing your home. And that's, Ken, unless you have other thoughts, I don't have anything else I can say about the statutory notice of delinquency.
Well, I think if you are providing a document which is required by the state, that it is not going to be considered a threat by the board or the association or the manager to take your home. Clearly the legislature thinks there's a problem with owners who are losing their homes because they didn't get early enough notice, and they didn't get the financial resources or legal help notices that might have prevented them from losing their home. And so, the legislature has stepped in to solve this problem, and they did it in a way which I think many of the lawyers and our legislative action committee for CAI did not think was a particularly great way to do it, but they didn't really want to listen to us. So, it's kind of like, when do you send it? The notice is required to be sent within 30 days of the payment not being received. So we have a lot of clients where they don't assess a late fee or send a delinquency notice until 10 or 15 days after the payment is due. But under the statute, you start counting 30 days the day the payment's due. You don't start counting 30 days when the payment is 15 days past due. And so you might be sending a delinquency reminder to your owners at 10 or 15 days, and then you still have to, within the 30 days of the missed payment, send out the second notice. So you may be sending 2 notices out within a month.
Yeah. Yes, and if that's a perceived threat on the part of the owner, that's different than the intent of the document, which is to provide a lot of information to owners about resources that they have at their disposal to avoid further collection action.
But it also may stimulate more owners to just pay because they perceive it as a threat.
Yes.
So maybe it'll have a beneficial effect.
Follow-up question to that. The notice of delinquency will come from the HOA, and the owners will not differentiate between the HOA and the state, don't you think?
Talk to your legislature.
All right, so next question. Regarding the resale certificate, if previous construction violated city code, which was not corrected, would that be an exception to not having to include a previous project's results in a resale certificate?
Well, the resale certificate has one of the questions, which is that the association is supposed to identify code violations in the units and in common elements. So if the board knows there is a code violation, then it needs to identify it. If there was a code violation in 2010 and then repair was done and the city signed off on it, then there would not be a code violation anymore because the city signed off on it. So it sounds like you've got some really specific details that you need legal advice on, which we cannot provide in this forum.
And I would only add to that what Ken mentioned before regarding resale certificates and the fact that the CCRs are public record, as well as, any type of code or any type of code violations and those are public record as well. So if an owner is seeking information, a buyer, or about the property itself, they are welcome to visit King County or Snohomish County or whatever their county records department and do their own digging. None of these are, all of this information is public record. Correct me if I'm wrong, Ken, but I believe that's true.
Well, the challenge would be that if the board knew of a code violation that had not been reported to the city or county, they would still need to report it on the resale certificate. But we have a lot of situations where the board may believe work was done without a permit, and it may have been done without a permit, but that doesn't necessarily mean that there's a code violation. And I'm okay with boards making factually correct statements within resale certificates. So if they, if a window was added to a unit without the approval of the board or the city, they could state a window was added to the unit. And that's different than stating that the window's a code violation, because I don't know that the window's a code violation. But again, it sounds like you may need to consult with an attorney on the specifics in your case and for your document. Anything else, Chelsea?
This one might be too specific, but I'll run it by you. Due to 3 lawsuits and coming out of receivership, our HOA is broke. No reserves and considerable repairs required now. Assessments to cover the costs have been approved, but over time that will delay repairs. A director has suggested that he cover the repairs and the HOA reimburse as funds are available. The board is okay with this. Is this a problem?
Well, I will say that's a very specific question. If the question were rephrased as, can an association borrow money to take care of repairs? And could the money be borrowed from a private person rather than a bank? You know, we certainly have had a number of clients that borrow money in order to repair buildings and then repay over time. It still requires a special assessment. It's just the payments are due over an extended period of time. We have had clients where private individuals have made loans to the association in order to fund projects instead of borrowing money from a bank. And so I don't know how much money is involved here, but if you are borrowing money, whether it's from an individual or a financial institution, you need to make sure that you're complying with your governing documents with regards to any restrictions on the borrowing process. And you'd have to comply with the requirements to have a special assessment in order to repay any loan. So it's, you know, again, it is specific, but as a general rule, there's nothing that would prevent a private individual from loaning money to a HOA for a legal purpose. Any other short questions? We got just a couple minutes.
Nothing has, someone asked if we can cite an RCW on the previous question about resale certificates.
6490, 640 or 6434, 425 are the resale certificate statutes.
And it's a list. So you can almost use it as a checklist, actually.
It is a checklist.
It is
yeah.
a checklist.
All right, that's all the questions that I've gotten.
All right. Well, thank you, everyone. I guess
Thanks.
we'll see
Have a
people
great
next
day.
week.